mention, we're going to be talking about the fifth element of libel, which is fault, and it gets its very own PowerPoint because it's kind of complicated. And it leads us to probably the most important media law case of all time, which is New York Times versus Sullivan, which was decided by the Supreme Court in 1964. The background of New York Times versus Sullivan is this. So in March of 1960, the New York Times had a full-page editorial advertisement, which is reproduced here, and you can actually go online and get even nicer versions of this if you want to see it. But it is called Heed Their Rising Voices. And it was placed by a civil rights coalition that was fighting for equal rights in the South. And obviously the early 1960s, late 1950s, this is the time when the great civil rights movements in the South were going on. And there's lots of upheaval. There are lots of white people, especially white officials, who are fighting the idea of civil rights. And so you have a lot of conflict going on. And essentially this ad says that many officials in the South have been using violence and illegal tactics to try to thwart the civil rights movement. And what came out in the trial eventually was there were a couple of small factual errors in this ad, but it is true overall. And a couple of clips that I've highlighted here that are quotations from the Heed the Rising Voices ad. You can see this one, which once again I will just sort of allow you to pause and read on your own. And then also we have this one as well. And I'm actually going to read this one because it is important. So again and again, the Southern violators have answered Dr. Martin Luther King's peaceful protest with intimidation and violence. They have bombed his home, almost killing his wife and child. They have assaulted his person. They have arrested him 7 times for speeding, loitering, and similar offenses. And now they have charged him with perjury, a felony under which they could imprison him for 10 years. So as a result of this ad, the police commissioner in Montgomery, Alabama, and police commissioner is more or less like a police chief, he sued the New York Times for defamation. His name was L.B. Sullivan. That's the initials, L.B. Sullivan. So he sued the New York Times for $500,000. And what he essentially says is that these references to the police identify him, and he says that these passages make it seem like he tried to starve students, like he had arrested Martin Luther King illegally, and that he had encouraged other people to testify against Martin Luther King's family. And in fact, during the trial, Sullivan brought in people who basically said yes. When they saw this ad, it caused them to view Sullivan in a negative way. So the trial court actually ruled in favor of Sullivan, as did the Alabama Supreme Court. However, the New York Times appealed this to the United States Supreme Court, and the Supreme Court reverses. And they essentially said that Sullivan can't recover damages unless he can prove either that the paper knew the statement was false, or it exhibited what they called reckless disregard for the truth. Okay, so I want to talk about these standards here sort of in reverse order. So first of all, private persons only need to prove negligence. So what does negligence mean? Negligence essentially means just failure to exercise ordinary care. And negligence is a legal issue that comes up in other types of cases as well. For example, if there is an accident of some kind, For example, like recently a train wrecked on the East Coast, and right now they're sort of investigating, like, was this the driver's fault? Was he negligent? Did he do something wrong? What happened? And so negligence is essentially, we ask, what would a reasonably prudent person do in these circumstances? And if the person didn't do those things, well, they may have been negligent. So in journalism, we might ask, did they follow accepted journalistic standards? So did they check their facts? Did they, you know, were they skeptical of untrustworthy sources? Did they interview more than one person? And so these would all be sort of things that would go into asking, were you negligent? Now, actual malice, on the other hand, is a bit more serious. Actual malice essentially means that either you knew something was false and you printed it anyway, or you should have known it was false and you printed it anyway. So the court uses this concept of reckless disregard for the truth. So essentially, if you have a reckless disregard for the truth, you're going to ignore anything that basically, goes against what your story is, and you're just going to include the stuff that basically fits your agenda of the story. And so, again, the important thing here is that private people only have to prove negligence, whereas public officials have to prove actual malice. And let me just one more time give you this actual malice thing, because it is hugely important. So what we're saying here is, if you are a public official or a public figure, you have to prove that either the media organization knew what they were printing was false and printed it anyway, or they should have known and they printed it anyway. Okay, and so that's actually a pretty serious charge. And, as you might guess, that makes it very hard for a public official or a public figure to win a libel suit in the United States. So as a result of New York Times versus Sullivan and some later cases, we get these various classifications of public and private people. And the four that we are going to talk about are going to be public official, all-purpose public figure, limited purpose or vortex public figure, and private person. And once again, the reason we're talking about these different types of people is because depending on who they are, it determines whether they have to prove negligence or actual malice to win a libel suit. So let's first of all talk about a public official. So a public official is going to be somebody who has an important job in government. So this could be a mayor, a governor, a president. Essentially, anybody who is elected is considered a public official. So if the mayor is elected by the people, if city council is elected by the people, if the dog catcher is elected by the people, he or she is considered a public official. And there are also like a wide range of other people who aren't elected, who are considered public officials. And the key thing is whether the person that we're talking about either has or appears to have substantial responsibility for government affairs. So again, if you're somebody who maybe you weren't actually elected, but you're the person who is actually keeping track of all the finances for the particular city, that would be somebody who would be considered a public official, because they have power over the budget, which is a huge thing for a city or any kind of government entity. Another interesting thing is that police officers are considered public officials. Even though they are, not high up in the, running of the government, they do walk around carrying guns, and they more or less hold life or death power over people on a daily basis, which is something that we've, obviously has come into the news here in the last few years. So again, if public officials are going to be any kind of like elected person or somebody in government who has or appears to have substantial power. So when we're talking about whether they have to prove actual malice or negligence, we look at the type of job, which we just talked about, and then we also look at the nature of the story. So for a given story, the person might not be considered a public official. So if the story is about something that has really nothing to do with the way the person does their job, then they don't have to prove actual malice. They just have to prove negligence. So as an example here, let's say we did a story about um, the zoning commissioner of the city of Perrysburg. And zoning commissioner, hold on one second here. Excuse me. Zoning commissioner is going to be somebody who kind of like makes decisions about, what kinds of businesses can go where, like how tall your shrubs can be in front of your house, that sort of thing. And let's say we do a story about Perrysburg's zoning commissioner, and we study and we find out that the person has a lot of credit card debt. And in fact, they've got so much credit card debt that they're in one of these situations where they've just been paying the minimum each month, and their credit card debt is going crazy through the roof. So in this particular kind of case, this story really doesn't pertain to the way that person does their job. Because again, the zoning commissioner doesn't really have to keep track of finances in their job or anything like that. And so it really wouldn't be considered a story about how they do their job. But if we did that same story about the city's finance director, well, then you could make the argument that yes, that is a story about how fit they are to do the job, because they're supposed to be the person who is keeping track of all of the finances for the city. And if they're having this much trouble with their personal finances, there's a pretty good chance that they're not very good at work as well. And so again, we sort of have to consider the nature of the story as well. And so if the story is really not about how they do their job, well, then the person wouldn't have to prove actual malice. So there are some exceptions here. For example, the president is basically open to nearly complete scrutiny, as we have seen over the past several presidencies. So in effect, any aspect of a president's life is basically, open season for journalists. And in order for the president to win a libel suit about almost anything, he would have to prove actual malice. So next we come to what is known as the all-purpose public figure. And this is basically, a public figure is going to have the same kind of standards as public officials, but they don't necessarily work for the government. So an all-purpose public figure is going to be somebody who basically has so much power and influence, and we care about so many aspects of their life, and they have publicized so many aspects of their life, that essentially any story the media writes about them, in order for them to win a libel suit, they would have to prove actual malice. And so courts have actually only ruled in a couple of cases that a few people are officially all-purpose public figures. And actually the cases in which they did that are so old that most of the people are dead now. But for example, Johnny Carson, who used to be the host of The Tonight Show, and was, really somebody who was really well known, like from the 60s all the way to the early 90s. He was actually ruled to be an all-purpose public figure. Wayne Newton, who is, I think he's still alive, but he's sort of a singer who now has like a big act in Vegas. Your grandfather might know about him. And so those are the kind of people who have actually been ruled to be all-purpose public figures. And again, these are people who are more or less exposed to nearly total media attention. And because of that, more or less any aspect of their life is fair game. And once again, what's important here is what that means is that if they're going to win a libel suit, they're going to have to prove actual malice against the media. So I would say, for example, people like Paris Hilton are probably all-purpose public figures. I think Oprah is an all-purpose public figure. I think Kim Kardashian is an all-purpose public figure, as is probably one or more of her sisters. I just barely know about the Kardashians to begin with, but just the fact that I know so much about Kim Kardashian and I have never set out to learn anything about Kim Kardashian. I've never asked anybody, tell me about Kim Kardashian. And yet I know all this stuff about Kim Kardashian. Once again, I would say she is what we would consider an all-purpose public figure. And once again, the important thing about an all-purpose public figure is the only way they're going to win a libel suit is if they can prove actual malice. So then we get into what is called the limited purpose public figure, which is also termed a vortex public figure. And this involves people who might not be known otherwise, but in certain kinds of circles or certain kinds of issues, they are well known. And so they are people who have more or less kind of become involved in an issue that's maybe a public controversy of some kind because they want to influence how that is going to be played out. So the most famous one here was a guy named Melvin Ruber, who was a cancer researcher, and he was somebody that really nobody knew, but he kind of went on a crusade against a pesticide called malathion. And so he did a lot of research about malathion. He presented papers. He gave presentations, all across the country, even before Congress. He had press conferences, and he was basically ruled to be a vortex public figure. So even though most people didn't really know who Melvin Ruber was, when it came to cancer research and when it came to pesticides, he was considered a public figure. So what that means is if Melvin Ruber, if we did a story, something about his cancer research, then he would have to prove actual malice. Okay? But if we did a story about just Melvin Ruber's personal life, or maybe that he left a restaurant without tipping or something like that, in that kind of case, since we really don't care about Melvin Ruber other than his cancer research, in that case, Melvin Ruber would only have to prove negligence. Okay? So a limited purpose public figure is really just a public figure for, a limited topic. Once again, not many people probably in the public would know who they are, but if we talk about a particular group of people or people who have a particular interest, they would be considered a public figure. And so then we get to finally private persons. And private persons are more or less everybody else. So people like me, people probably like you, just people who are more or less just walking down the street, we have some friends or whatever. Some people might know who we are, but generally speaking, we're not in the spotlight. We're not, well known to people at all. We're basically just private people. And so private people in all libel cases only have to prove negligence. So one thing you might be wondering is like, why is this the case? Like, why do we, make it so hard for public officials and for public figures to win libel suits? Well, there's two reasons really. So for public officials, we're a democracy and we depend on people knowing about what's going on in their government. So we are, as a country, basically going to be very hesitant to restrict speech about that. And so we don't want the media to be worried about printing something if they're going to get sued for libel and if they're going to lose. And so we basically make it hard for somebody who is in government to win a libel suit. And when it comes to public figures basically have access to the media on a daily basis in a way that people like you and me don't. As an example, if like Kim Kardashian just walks out of her house, she's got like cameras following her. If she stops and talks, you'll see it, on the internet, you'll see it on TMZ, you might even see it on the nightly news. And so public people basically have access to the media in a way that private people don't. So for these two reasons, this is essentially why it is so difficult in this country for for public officials and public figures to win libel suits. So this slide then sort of summarizes what we've just been talking about. So the actual malice standard, which again means that you either knew something was false or you should have known and you printed it anyway. This is what actual malice is, and the people who have to prove actual malice would be public officials, all-purpose public figures, or limited-purpose vortex public figures. So any of these kinds of people, if they're going to win a libel suit against the media, they have to prove actual malice. On the other hand, negligence, which is a much lower standard and much easier to prove, is going to be things like private people, and also, as I have here in red, public officials or public figures if the story isn't about legitimate public concern. So once again, this idea that I gave you of the example of the credit card debt. Does it actually speak to the person's fitness to do their job? If it does, then they would have to prove actual malice, and if it doesn't, then they would only have to prove negligence. So this is really important to kind of grasp this and to grasp the difference. If you're struggling with this, please post something and we'll try to do something to clarify it. But it really is important, and it is important that you understand this difference and what it means. So as a way of maybe helping you understand that, I want to talk about two cases that were actually combined into one by the Supreme Court in 1967. So the first of those cases was Curtis Publishing versus Butts. And Wally Butts, that's a great name, first of all, Wally Butts, he was the athletic director at the University of Georgia. And the Saturday Evening Post, which was a magazine of the time, a very popular magazine, printed an article where it said that Wally Butts and the Alabama football coach, who at the time was Paul Bear Bryant, who is a very famous football coach, they did this article where they said that Butts and Bear Bryant conspired to fix the Alabama-Georgia football game. So the information came solely from a guy who basically said he was trying to make a phone call when he was accidentally connected to a conversation between Butts and Bryant in which he heard them talking about this. And, again, the world has changed a lot since 1967. I can tell you that having grown up in the days of old school phones, this is something that was not crazily out of the ordinary. I can remember, there would be times on occasion where you would just like pick up your phone, and rather than having a dial tone there, you might hear a couple of people talking. And so you would basically like kind of click the receiver to, hang it up a couple of times, and then it would go away. But again, I'm just sort of telling you this because even though that sounds kind of like pretty far-fetched, it could happen. So essentially, this Butts sued for libel, and a lower court basically wanted to award Butts $460,000 in damages. So this is appealed to the Supreme Court. The second case is AP versus Walker, and this involved a wire service report that said this Major General Edwin Walker had encouraged violence at the University of Mississippi in 1962. And once again, we're talking about the civil rights movement. There were civil rights protests going on, and basically the wire service report from the Associated Press essentially said that Walker had encouraged violence and led a charge against federal marshals who were trying to integrate the campus. In fact, what Walker had done was merely calmly talk to a group of students. He urged them to protest peacefully, and the Associated Press got this information from a stringer who was normally pretty reliable but was under deadline pressure. And so in this case, the court found that there was no actual malice against Walker. But again, this gets appealed to the Supreme Court. So essentially the criteria here when we're talking about, what is the difference in these two cases? First of all, we look at let me back up here a little bit. So why was there one decision in the Butts case and another decision in the Walker case? Okay. So first of all, we talk about the sources used. So in the case of Walker, we had our source was a stringer. And a stringer is basically somebody that a media organization hires to cover news stories in a particular area. And this was a stringer who was normally reliable, who had, given information before, and it had always been good. And so we believed the person. In the case of Butts, the information came from this guy who basically said that he just picked up the phone and happened to hear this conversation. It also turned out that that guy had a criminal background as well. And so when we look at the two sources used there, we can see a pretty significant difference. Where in one case, the media relied on somebody who was, reliable and accurate. And in the other one, they relied basically just on a guy who had this kind of far-fetched story and who had a criminal background. Secondly, we look at standard journalistic practices. So this means, for example, the difference between an investigation and spot news. So the Curtis Publishing versus Butts was more or less an investigation story. It was a story about a football game that happened the year before. There was really no pressure to put out this story like on a timely basis. I mean, they could have, held on to it and kept researching it for, a few more weeks or a few more months. So they had time. They could have checked more into this. In the case of AP versus Walker, this was more or less a breaking news spot story. And so, they had to basically get it out. It was under deadline pressure. And so, again, it was, just something that had to be turned around much more quickly. Third, the believability of the story. Already we talked about the Butts case where the guy just picked up the phone. Again, that's a little unbelievable, but as I said, not totally out of the ordinary. The other thing with Walker is in the past, Walker had actually encouraged violent protest. So this Major General Walker was somebody who we knew, and we had known in the past that he had actually encouraged violent protests against civil rights. And so once again, it seems to be a fairly believable story. Fourth, we look at deadline pressure. And again, this is sort of related to the standard journalistic practices. Was this a hot news story, which basically is what AP versus Walker was? It's a breaking news story. It's happening now. We basically need to get on it. Or was it about a game that happened, years ago? And so again, there's like a much different deadline pressure between these two stories. And then finally, the court looked at motivation. And the Saturday Evening Post had recently initiated a new muckraking policy where they basically said, hey, we're going to do stories, we're going to go after people, we're going to, basically afflict the comfortable and comfort the afflicted. We're going to get out there and we're going to, bust some people. And so there was motivation for the Post to have a high-profile story like this. So again, looking at all of these differences, this is basically how, we would look at an example of cases where there were two different things decided. So in the case of Curtis Walker, Curtis Publishing versus Butts, there was a finding that there was actual malice, and in the case of AP versus Walker, there was a finding that there wasn't. Okay, so just to review here, we have finished talking about fault. And so you now basically know the 6 things that a defendant has to prove in order to win a libel case. And so in the next PowerPoint, we'll talk about some of the things that can actually defend you against a libel lawsuit. So in other words, if you are a media organization and you get sued for libel, what are some of the things that can actually get you out from under that? Okay, see you later.